through that process, by the time 1L has ended, students are now significantly more pacified than they were once starting, which really impacts the way that they think about their legal career and think about what a legal career even is supposed to entail.
And instead of calling those lawyers out, instead of naming that phenomenon, we've allowed them to enter institutions, to teach future law school students, to also craft the narrative around our politics and the way we exist as a society.
If you go to Skadden's website, you see them bragging about their volumes of pro bono work, and they brag about how 65% of their lawyers do 20 or more hours of pro bono a year. 20 hours is not a lot of pro bono. The ABA requirement, or the ABA recommendation is 50 hours a year.
It's been the only time I can really remember a heavy doctrinal class, a professor asking me to remember why I came here. And I think that's really important because it's so easy to feel wait, everyone's talking about this big law recruiting event, or everyone's talking about this other thing, maybe I'm missing something, and maybe it's me and it's actually my fault, where it's definitely not.
Starting off, you don't really notice it so much. I mean, I just kind of went home for break and I was like, wow, so much of what I'm getting at law school is free because these corporations are paying for it. I get to go to free lunch every day, and bar review is paid with free drinks paid for by law firms and all this stuff.
70% of our students will go into big law. And a lot of those students do it not because they have this dire need to support their family back home, which is very real. But for a lot of students, it's because it's the easier path.
It's sort of why are you so willing to give up your agency and your one shot at making justice real and pursuing a transformative legal career just because you believe so much that everybody deserves a lawyer? That's not what this is.
And I think that the legal profession would be really a lot better if Exxon got turned away from Paul Weiss and Cravath and Wachtell, and they shut their doors to them and said, we're actually not going to help you do this terrible thing.
And if you're here, or if you're just interested in the flaw, getting connected to the flaw, I think has been really, really grounding for me throughout law school, and every semester when I'm maybe I won't take critical corporate theory because there's this other class I'm interested in. I'm how could I go a semester without this community that's kept me so grounded here?
So this panel today is going to focus on the corporate capture of legal education and the legal profession. Here to talk with me are 6 students that have all written about their experiences in the law school and their research about the legal profession in one form or another for The Flaw. You can read all of these excellent articles in the print edition of The Flaw, available to all of you today, and also at theflaw.org. Highly recommend following our Instagram and Twitter accounts as well, at theflawmag on Twitter. So I'm going to quickly introduce myself. My name is Lisa Fanning. I am a 2L here, and I've been a member of The Flaw for about a year now. Last year, I wrote about the corporate origins of conservative legal thought, with a particular emphasis on the Federalist Society. Boo. And I'm now going to just pass it down the line, and if everyone can just quickly introduce themselves. I should say my pronouns are she, her, and if you could all give pronouns as well, and then just the title of your article, brief sentence about what it's about.
Hi, I'm Marty. I'm a 3L, he, him. I'm going into public defense after law school. I wrote an article. I was with The Flaw, joined the lab last spring, and wrote an article called In Search of Sunlight. What was it called? How Corporate Law Careers Outshine All Else at Elite Law Schools, basically about how the ways in which certain career opportunities in big law are spotlighted here, and students are sort of directed to them along a moving walkway at the expense of public interest careers.
Hi everyone, my name's Rosie. I'm a 3L. My pronouns are she, her, hers. I joined The Flaw last semester, and then the semester before that wrote a paper in my corporations class about the capture of students of color into big law.
Hi, I'm Noelle. I'm a 2L. I use she, her pronouns, and my article is called The Price of a Harvard Lawyer, which is about how corporations essentially buy law students by paying for our academics, extracurriculars, and social lives on campus.
Hi, I'm Sam. I'm a 3L. Like Marty, I'll be going into public defense after graduation. I joined the Critical Corporate Theory Lab last fall, not this past fall, if that makes sense. And my article is The Corporate Origins of Common Good Constitutionalism, which is basically talking about how what promises to be the next big theory in the conservative legal movement and seems to be anti-corporate is actually very pro-corporate and corporate funded.
I'm Ellie. I'm a 2L. I use she, her pronouns. I was in the lab the spring of my 1L year. My article's called The Dirty Work of America's Legal Darlings, and it explores the harm that elite appellate lawyers are causing by representing corporations largely in federal appellate and Supreme Court litigation.
Hi, I'm Logan Campbell. I'm a 2L. I use he, him pronouns. I was in the lab last semester, and I wrote about, my article is titled What Good is Pro Bono, which talks about the more sinister side of pro bono.
Great, thank you all. So I want to start out by talking about a typical law student coming to Harvard Law School. Most students don't come to law school dreaming about a career in big law. They're not writing on their personal statements that they really want to represent Exxon. So how does it happen that so many of them end up doing just that? And I'm going to start this question with Noelle. You wrote about some of the social pressures that can really influence what a student experiences once they get onto campus. Can you tell us a little bit more about that?
Sure. So in my paper, also can you hear me okay? Okay. In my paper, I talked about how a lot of the academics here and then extracurriculars are funded by corporate law firms, like I was saying in my introduction. And I think that starting off, you don't really notice it so much. I mean, I just kind of went home for break and I was like, wow, so much of what I'm getting at law school is free because these corporations are paying for it. I get to go to free lunch every day, and bar review is paid with free drinks paid for by law firms and all this stuff. And I think that whenever you go through a lot of that and just have a lot of free stuff given to you by corporations, it is subconscious convincing into going into corporations, which is kind of what I wrote about in my paper too, comparing it to the medical field and how doctors are subconsciously influenced to sell prescription drugs, and they've actually, or brand name drugs, sorry. And they've actually done studies and psychological studies on that area, but not so much with law school because it's kind of hard. Everyone undergoes the same thing, so they can't really separate people who have had free lunches from corporations from people who haven't. But it's interesting to compare how you can be subconsciously influenced by things like a free lunch or a drink.
Yeah, definitely. And so many of our rooms and buildings are named after these firms too, so it's in the water here. But more than the subconscious pressures and the social pressures, there are some really big incentives for big law and going into those careers. Marty, you talked a lot about the financials of it and what students are facing when they're looking between, really big starting salaries at a firm versus what it might look like in the public interest sphere. Can you explain a little bit about the choices that are being presented to Harvard Law students and how you see students navigating those choices?
Yeah, I think basically over the years, the amount of debt that students are leaving law school with has just absolutely ballooned to, hundreds of thousands of dollars of debt. And in a lot of cases, the choice is framed as this binary of, do I go to a firm and get $200,000 a year, or do I go to public interest and get, $60,000 a year, which is sort of painted as, being poor, even though it's actually a very reasonable salary to make. But in light of the debt, it becomes a huge issue. And then there's another factor compounding it, which is that Harvard has loan repayment assistance programs to repay the debt, but they're not always effected in the best ways possible that they could be. They take into account assets that people might not have access to, like their retirement assets. Their homes are counted for their full value, even if they have mortgages. If people are married, Harvard will average up according to a spouse income, but not average down the other way. So there's lots of different better ways that Harvard could help students alleviate that debt burden, but the choice is really framed as just big law is the typical way to pay off the debt, and you might as well do that.
Yeah. Thank you. I actually did not know that about them not averaging down to a spouse's salary. Learning fun things every day at this place. And I want to move to Rosie now because you tackled a similar question, but with a specific lens on how students of color are really targeted by law firms in recruitment. And something I thought was really interesting in your piece was not just that students of color are more likely to come from backgrounds that make these pressures intensified. It makes that choice even more difficult. But also that firms are doing this because they have a financial profit motive to diversify their firms. And I wonder if you could talk a little bit more about that, because I found that really illuminating.
Yeah, definitely. So there has been an increase in investor pressure amongst large corporations, especially tech companies, and then in turn law firms to increase the diversity in their firms. So for example, there's been a movement called ESG, which is environmental, social, and governance work, in which it's been proven to investors that in order to increase the triple bottom line of a company, so to maximize the profit of a company, having a more diverse workforce, treating employees better, improving the environment, or at least decreasing environmental damage will actually help benefit a company. And while these seem like very good, sound motives, oftentimes the way this is implemented in large corporations like tech companies and like law firms is that they take a surface level approach to try to meet those numbers to satisfy investors without actually solving the more deep-rooted problem, which is that people of color have a lower access to these spaces because of all of the institutional inequity that's created by these types of corporations. And so this Band-Aid solution has resulted in students of color from various law schools, and in my research, particularly from Harvard Law School, to kind of be baited into going into law firms without providing them with other types of options or incentives to pursue something that might be more satisfying to them. And at the same time, these law firms have these numbers, so they're increasing the diversity within their firms, but the leadership track and the partnership track doesn't allow for people of color to rise up. And so that's also where you kind of see that Band-Aid solution breaking a little bit, is that there's a high number of people of color within the associate class, but then once you see partners, they don't really exist there. And I think that just goes to show one of the cons of having a system like this to increase diversity.
Yeah, it's really fascinating, and specifically the thought of coming onto a campus as a student of color and knowing that, and maybe not knowing, but that there are people who have financial interest in you taking one career path over another. It's a really intense pressure to face. And you also spoke a little bit about, and you spoke to some other students about what that feels like. Someone described it as a surreal place where none of the issues that are happening in the world are being discussed. And I want to just take a moment to talk about the way that the law and law school has tried to neutralize what are very salient political topics that have real impact. And if you could just give a quick word about the experience, particularly from your perspective as a student of color, of coming to a place that tries to theorize about things that have real impact on people.
Absolutely. So as has been spoken about before, students often come to law school with very idealistic visions of what they want to do with the law. They've seen problems in their lives. They want to come to law school because they see law as a tool to change things. And then they enter their 1L year and they are taught heavy doctrinal classes where they are asked to only talk about legal reasoning and the law and not talk about the problems that this legal reasoning and the law causes. And so instead of having students of color who also have very particular experiences with the law and who have faced the damages that the current legal reasoning and thought creates, rather than promoting and allowing them to think more deeply about that, think more deeply about those experiences. How do you think outside of the box and change the way the law is implemented or the law is created to create a better world for them? They're instead asked to work within the confines of the doctrine. And I think that this is a really pacifying process for all students who come in with those types of visions and who want to go to law school to talk about those types of things. And it's particularly salient for students who have personal experiences in which the law has harmed them in some type of way. And so through that process, by the time 1L has ended, students are now significantly more pacified than they were once starting, which really impacts the way that they think about their legal career and think about what a legal career even is supposed to entail.
Yeah, thank you so much for that. Something that resonated a lot was the pacifying influence of being told that really harmful theories are neutral. And I know, Sam, you explored this quite a bit with your work on common good constitutionalism. I'm going to pause for a moment because I wouldn't be doing my duty as an angry lesbian in law school, trademark pending, if I didn't mention that we're talking about a homophobic academic coming off the tails of a week where a queer student on this campus was attacked violently using homophobic slurs against them. So these aren't just theoretical topics. These have real impacts on people's lives and on student lives. But we're taught that it's okay to discuss them, it's okay for our teachers to proliferate these ideas, and that it's okay to agree with them in some cases and maybe not all. And so, Sam, can you talk a little bit about what common good constitutionalism is and how it's taking over this campus?
Yeah, I'll try to be brief about it because I can speak a lot about it. Basically, it's a theory that was created by Adrian Vermeule, who is a professor here. A lot of people take his administrative law class. Basically, the theory is that originalism and textualism have served their purposes, and now we have to move on to something else to achieve our greater goal of like capturing the legal system and capturing society. And it's really interesting in my article, I really dive into how difficult it is to figure out actually what's going on in the theory. And I mean that because it seems like there's a lot of hiding the ball. It is definitely outwardly homophobic. It's based on Catholicism and Catholic ideals of putting everything only second to God. And I'm trying to think of without just going on and on about it. And it's just really, it's basically trying to reach the conservative agenda, but really trying to make it like we're objectively moving towards the common good, and this is good for everyone. And so anyone who disagrees, it's like they throw out ad hominem attacks, like you don't know what you're talking about, and maybe if you read my book, you know what you're talking about. And in October, the Federalist Society hosted the Common Good Constitutionalism Symposium, which they kept under wraps for a very long time, but I was able to attend, and it was framed as a debate conversation, but it was not a debate at all, and it really ended up being a way of blending originalism with common good constitutionalism as like the next big thing for us moving forward. One of the only critics at the conference who spoke was Professor McLean from BU, and she spoke about how the theory doesn't talk about the practical implications, especially being based in homophobic, sexist, racist ideals. And Professor Vermeule was one of the only people, she was one of the only people Professor Vermeule responded to at the conference, and he basically said, you didn't read my book, you don't know what you're talking about. Whereas I read the book, and it seems like she's really onto something. And interestingly, I will wrap this up, but interestingly, Judge Ho, who was present at the conference, really encouraged Vermeule that if he wanted this theory to stick, he had to really get it locked in legal education and really start building his classes around common good constitutionalism. And so this semester, students might know that he is really building the classical legal tradition, what he calls it, into his classes. He's teaching a seminar on it and teaching administrative law again. And it's basically fed to students as like, you should think about this seriously. It's not, it's in everyone's best interest, but if you really read between the lines, or maybe just actually read what it says and not between the lines, it's pretty clearly very harmful.
Yeah, thank you so much. And I think that the sort of like slipping it into legal education and watching that pay off over the generations is a really common theme in how the law shifts over the years. So Ellie, I'm going to shift to you now because you really explored this in the appellate landscape and how some of these lawyers that are, placed in front of us as paragons of the legal profession and what we should all be aspiring to achieve as the appellate lawyership, the best thing you can do as a lawyer. But they're changing the law in ways that is really harmful. Can you talk a little bit about that?
Yeah. I think the lens that my article and sort of what I explored took is exactly what you described, Lisa, is that there's a group of really esteemed, lionized appellate lawyers who teach at institutions like this one, who write op-eds, who appear on CNN, often talking about the importance of democracy. They're very much part of sort of mainstream democratic politics, but at the same time, what they do in their downtime is they represent very large corporations in really terrifying lawsuits that seek to impact federal law. And I think that lens is really important because these are not, big law associates. They're not students who have come out of law school in their first or second year. They're lawyers who've been the Solicitor General for the United States. They've clerked on the Supreme Court. They've had they could take any possible avenue in their careers, and instead they've chosen to represent UPS, for example, in a lawsuit that sought to narrow the protections of the Pregnancy Discrimination Act, or Johnson & Johnson in lawsuits seeking to skirt liability for knowingly putting cancerous talc in baby powder that millions of Americans have used. So these, sort of building off what you're talking about with Sam, these are not neutral enterprises. They have very, very specific goals in crafting precedent that more and more corporations down the line will use to cause even more significant harm. And instead of calling those lawyers out, instead of naming that phenomenon, we've allowed them to enter institutions, to teach future law school students, to also craft the narrative around our politics and the way we exist as a society.
Yeah, definitely. And to your point, these aren't first or second year associates, but I want to talk about how these appellate lawyers got there. And they did get there by starting at firms. And they probably didn't think at the outset that they wanted to defend UPS against a pregnant worker. But they did it anyway, and they started at a firm. And something that is often propped up as a pacifying or something to make it taste better as it goes down is that you get to do a lot of pro bono work when you're at a firm, and firms will tell you how much good they're doing, and it's on their websites, and they'll have their students talk to new 1Ls about it. But Logan, you wrote about some of the realities of pro bono and what it's actually accomplishing or not accomplishing. And I'd love if you could just give us a couple thoughts on that.
Sure, yeah. Like you were saying, they sell students on this idea that, what would otherwise be public interest students on this idea that you can go make a lot of money, make $215,000 to start, and do good work. But for the most part, that's just not true. One firm in particular that I think is really renowned for its pro bono work is Skadden. They really try to sell students on the pro bono work. They have the Skadden Fellowship, which every public interest student applies for. But if you go to Skadden's website, you see them bragging about their volumes of pro bono work, and they brag about how 65% of their lawyers do 20 or more hours of pro bono a year. 20 hours is not a lot of pro bono. The ABA requirement, or the ABA recommendation is 50 hours a year. I'm sure plenty of students here have gotten hundreds already at their time here. That's nothing. So compared to the more harmful work that they're doing in big law, the pro bono is just a subset. These are profit maximizing firms. Their goal in pro bono is to be able to recruit these students, and once they get them, they kind of turn their back on that pro bono promise. And then also with that limited amount of time, these pro bono attorneys are often not that good. You only have 20 hours, so it's hard to be that good. But one of the interviews I did talked about how these pro bono attorneys like aren't good with clients. Like a lot of these pro bono attorneys like are used to just like pushing paper all day, and then they get a client for the first time and they don't know how to interact with them. One of the examples was like this all-white group of attorneys was afraid of their 14-year-old black client and asked if it would be safe to bring them to their office. And just like, if you have that limited amount of time, you don't have that capability to interact with clients, you're not gonna do effective pro bono work. Very ineffective, and also like not a lot of time to work on it.
Yeah, it sounds very white saviory and not coming from a place of community lawyering or the people that choose to do public interest work from the outset, which I want to come back to for a second, because there are students that come to Harvard Law School and work in public interest and have lucrative careers, and that's not a story that often gets told to 1Ls. I think Rosie reported that 70% or something close to it of Harvard Law graduates are going to go into a big law career. But I want to talk about that 30%. There are students that are making lives out of public interest work, and I'm wondering, and anyone can take a stab at this. What is it that helps students push back against the pressures that they're facing and make the choice? And it's not the same choice for everybody, but I'm wondering what are some tactics or strategies that you've all employed when trying to stay grounded in public interest when there's so many forces trying to drag you away from it. Ellie, I'm going to kick it to you.
So I think this is related to what you were just saying, Lisa, that there's like an important layer to establish first, and that being able to do public interest work is a privilege, and students who are able to do it are often come from backgrounds that have allowed them to, particularly financial ones, that there are many students who come to Harvard Law School who want to do public interest work but don't have the ability to do that, whether they have a lot of loans or they're financially responsible for friends, family. And for those people, doing big law work is a necessity, right? It's a necessity to help their parents retire, or a necessity to help put their sibling through college, or to just build the generational wealth that so many students of color, and particularly Black students, have been denied generationally. So I think that that's just like a good place to start this conversation from, because I feel really lucky that I will be able to do public interest work after law school, but that is largely because of my personal financial situation. And I think for me, sort of what has driven me through this law school experience that has been, sort of disorienting in a lot of ways, has been having a community of folks who are equally dedicated to doing public interest work, or at least share my values, even if they can't do that work immediately after law school because of some other situation. So that's number one. I think also just always remembering why I'm here. I came to law school with a very specific goal, and with a community that I'm accountable to back home. And so carrying that with me has also been really helpful.
I can take a little bit of a stab. I was definitely going to say community. I think that's been really grounding for me here. I would also say, and I recognize that this requires more of us when we're already trying to navigate law school itself, but thinking creatively. I think something that I've been talking with people a lot about lately is how, for instance, plaintiff side work is kind of where do you go for advising on that at the law school? It seems like OCS, which handles private law, does some stuff with it. Seems like OPIA, which does public interest stuff at Harvard, does stuff with it, but it's kind of straddling in between. And I think asking questions of your advisors actually about how you might navigate that, how you might pursue that, is actually critical, because I don't think it's just going to be thrown in your face like big law firms will be throwing stuff in your face. And I think something else you mentioned, Ellie, really resonated with me, which is remembering why you came to law school. I remember during my first semester of 1L, my research and writing Clemenco is what they call it, basically a fellow, encouraged us to think about why we came here. And it was it's been the only time I can really remember a heavy doctrinal class, a professor asking me to remember why I came here. And I think that's really important because it's so easy to feel like, wait, everyone's talking about this big law recruiting event, or everyone's talking about this other thing, like maybe I'm missing something, and maybe it's me, and it's actually like my fault, where it's definitely not. And so just trying to stay grounded with your community, I think has been like so critical for me. And if you're here, or if you're just interested in the flaw, like getting connected to the flaw, I think has been really grounding for me throughout law school, and every semester when I'm like, maybe I won't take critical corporate theory because there's this other class I'm interested in. I'm like, how could I go a semester without this community that's kept me so grounded here? So I'll say that.
Yeah, go ahead, Logan.
Yeah, to kind of add to that point, something that's really kept me interested in public interest while here is just seeing the amazing student activism on campus and like some of its awesome successes, just like the students like fighting to have a reproductive rights professor, the students advocating for better lit policies, or even at the Kennedy School, the recent like Kenneth Roth activism, just like seeing the students, how passionate they are and how effective they can be, like kind of keeps me grounded, keeps me like we're in this fight for a reason, and we're Harvard Law students, like we can be effective and like go make change if that's what we care about. So that's really kept me invested in it.
Yeah, and Marty, I do want to shift to you because I know you talk a lot about something that's been brought up by a few people in this question, which is that there's sort of a pathway and a laid out step-by-step process for big law that doesn't necessarily exist in public interest. And I don't want to derail you if you were going to say something else, so feel free to start with that. But I would love you to talk about sort of the difficulty in navigating the stream of public interest.
Yeah, I think, well, the only thing is I would start just by echoing what Ellie was saying about pursuing public interest is a privilege, and just the public interest salary plus the poorly, like not enough loan repayment programs can align to make it basically untenable. And the other thing, I just to also recognize that like this panel is very white, and I don't want that to be like something that is not acknowledged here, because it is like an incredible factor as far as the kinds of people who are able to go into this. But yeah, the pathway is really baked into the way that opportunities are presented here. Students, somebody else wrote about this in their article, and now I can't remember which because I was reading them all last night, are just sort of bombarded by go and do EIP, the early interview program for corporate law, go do that immediately. Actually, it was Rosie you wrote about, right, like the diversity fellowships for 1Ls, they take a bunch of intensive classes, and then December of their 1L year are told, like, all right, go get into corporate law right now, and also this is the only job that's actually going to offer you money because summer public interest funding is very minimal. Everything top down to an advising, right? We have so Pete Davis wrote this great report called Our Bicentennial Crisis, which I know a bunch of us referred to as well. One of the things he takes note of there is that our advising offices, we have the Office of Career Services, which is just, this is your career. It's actually really the Office of Private Sector Career Services. And then if you walk a little further, we have the Bernard Coteen Office of Public Interest Advising, right? You can imagine a world in which those were flipped, in which the Office of Career Services was public interest advising, and then you have private advising as a separate thing. Another thing that's really big is wanting to chase prestige. I think, right, people who come to Harvard Law School and these elite institutions are interested in chasing prestige. It can be really easy to get that prestige through a big law career, especially sign up for EIP, you go interview at a bunch of firms, you don't even have to write a cover letter most of the time. Trying to find that on the PI route can be a little more difficult. Talking with David Wilkins, one of the things he told me was sort of a lot of people want to work at the ACLU or the NAACP, but once you get past those orgs, it's hard to find the sort of similar big name public interest orgs. And I think when people say that public interest is competitive, it's because they're only really looking in those specific localities or those specific really prestigious orgs and not considering this whole other world of public interest, like perhaps being a solo practitioner in the neighborhood, starting your own organization, which obviously is really, really tough. And I'm not trying to say that that is like necessarily the solution here, but Yeah, but there are a lot of other options that are just not presented to us.
Yeah, absolutely. And I think that that's by design. I mean, the
Yeah.
people that are paying for and funding our career panels and the options that are presented to us are those very firms that have a financial incentive in having lawyers from top law schools, because that's what gets them paid. So definitely, I really appreciate that point. And I think that, it's been mentioned by several of you, and I do really appreciate it, that for a lot of students, there is a real financial difficulty and there is a need to build generational wealth. And that can't be understated, specifically for students of color, and we should all be saying that anytime we're having a conversation about this binary choice. At the same time, HLS is not 70% students of color. No one's surprised by that. 70% of our students will go into big law. And a lot of those students do it not because they have this dire need to support their family back home, which is very real. But for a lot of students, it's because it's the easier path. And because it's presented to them and it's easier to just get on and stick with the current. So I think to those students, my question becomes, how do we shift the conversation about I'm just doing neutral work in an adversary system that is not changing the law, but merely representing a client, to what is actually happening at big law firms, which is shaping the real life consequences for communities that are gonna face the real harms of that corporate work. Because those people are not being represented in these hallways. Those communities where people are suffering from environmental racism, the pollution in their communities in Flint, Michigan, those people are not the ones that are making this binary choice. It's a lot of white students that could make the choice and choose not to. So I know that was sort of my own long diatribe. If anyone can find a question in there, feel free to take it.
I could take a stab at it. I think this really goes back to the pacification of students in law school. I was shocked my 2L summer to hear the way my peers talked about the type of work that they were doing, because they are such conscious individuals who are clearly very intelligent, who have made it into this institution and all the places that they'll go into, but somehow manage to describe very non-neutral work as being very neutral, I think, in a way to kind of justify the choices that are being made, which makes sense. But I think that all of that wasn't a personal choice. I think it really comes back to the law school experience. And so I think that the biggest way to alter the way that thought starts to begin to be created is by altering the way that we talk about our legal education in our first year of law school. So having more classes where folks can have intentional conversations about the impact of different types of work that they do, or having conversations even in their doctrinal classes where they have a better understanding of corporate power and corporate influence and what the impact of that work is. I think that that's a start, and I think that kind of decreases the ability of students to be able to justify the work that they're doing, because they're learning at an early age in their law school career about the actual impact of the work.
I can just very briefly add, I think going back to the community point, I think it's so crucial to build communities that can push back against that influence. I'm going to shout out Marty on this, but there is some posters downstairs that say you are not alone, and people who are going into public interest oriented work. And I mean, that was the effort of Marty and a few other students who were like, let's make this known. Yeah. Well, yes, I don't know them all, so that's what I'm saying. A group of students who were, put this list together, have people sign up, put their name down. And I feel like I've been talking about this a lot with people recently, is like building community is so important, because it really is easy to kind of find yourself being like, everyone around me is talking about something different and talking about going to this big law event or doing this sort of work, and you feel like you're like, I need to just stop talking because I don't know what I'm talking about. At least I can speak to that personally, being like, everyone's talking about going to this thing, but I don't care about it. Should I be caring? And I think community building is just so critical, especially in law school.
Yeah, I think going off of that point, it's really important to have a strong core community and then also values coming into what you're doing, and really take time to reflect on choices that you're making, which I feel like Professor Hansen has talked about before, it being hard to take time to self-reflect when there's so much coming at you year 1L year. But at the end of the day, I think it's really important. And I really thought about this a lot when I was interviewing some corporate lawyers for my paper who talked about the lack of self-reflection that went into what they were doing. And so I tried to look for lawyers who had argued big cases with moral implications, and I can't actually say what the cases are based on confidentiality with the lawyers that I interviewed, but there were some that I don't think a lot of people would feel good about going into when they start off law school, if that makes sense. But basically, some of them talked about not really knowing what kind of public interest they wanted to go into. Having one lawyer, actually this was someone who wasn't on one of those big cases, it was a newer associate, said that he knew there was a red line for him out there somewhere, but he didn't actually know where that was, which can be problematic if you just keep going forward and not really know when you're going to stop. So I think, like, for me, I have a strong family background, and I think that Ellie talked about privilege in terms of economics, and I also think that that comes into play with background. So like, I have a Catholic family that I kind of grew up to think about ethics and how my actions disadvantage or advantage others, and I think a lot of people who go into public interest careers are also privileged to have backgrounds where they've reflected on their actions before in ethics. And I think that if we can build community here, people can start to build those core ethical foundations even at law school.
That's great. So I want to, just as we wrap things up, shift to we've talked a lot about student choices, but really these choices can't be discussed without the people that are presenting them to us, and that is the corporations that have bought this school and the legal system. And so I want to ask this question particularly of Ellie and Marty, because you both did talk about this in your articles, but does everyone, and I say everyone, but corporations are not people, does everyone deserve a lawyer? Does everyone deserve and need representation, and does it have to be us that do it?
Go ahead, Marty.
Oh, okay. Yeah, I mean, I guess, right? Like, it's kind of like, I wrote about this as sort of a question that people hide behind, right? When they're like, well, everyone deserves a lawyer, so what are you saying? Like, I shouldn't go to big law because people don't deserve a lawyer? And it's my favorite response that I got interviewing people was like, well, that doesn't mean they deserve you. It's sort of like, why are you so willing to give up your agency and your one shot at making justice real and like pursuing a transformative legal career just because you believe so much that everybody deserves a lawyer? That's not what this is. Like, we have to be a little more honest about what is actually happening and what we're talking about. And the other thing that I got was that, yeah, people do deserve lawyers. If that's what you're thinking, you should go into legal aid and help all the people that really need lawyers. These corporations will find there's always going to be, well, hopefully not always, but right now there's always somebody lining up to take that gig and sell their, for money. So we fill in the blanks. Ellie, what do you think?
So I think the answer is no, that not everyone, when we include corporations, deserves a lawyer. And Marty, building off what you say, like, they definitely don't deserve really talented, excellent lawyers, but they also just don't deserve lawyers. They don't deserve someone standing up in court defending them. And I think that the legal profession would be really a lot better if Exxon got turned away from Paul Weiss and Cravath and Wachtell, and they shut their doors to them and said, we're actually not going to help you do this terrible thing. And the ABA has a standard, I don't remember the name or the number, but basically saying that lawyers should consider the consequences the responsibility, the ethics of the clients that they take. And we've really lost the plot on that one, where lawyering has become so divorced from the harm that it could cause down the line that we're able to hide behind things like everyone deserving a lawyer. And just another point on that, I think that argument often comes up in relationship to criminal defense. And when people are like, oh, you don't think everyone deserves a lawyer, what about public defenders? And I just want to take a second to say that those things are like vastly different. Because in a criminal case, we have the weight, the power of the government arrayed against one single individual. And in those cases, lawyers do not need to endorse the conduct of their clients necessarily, because they're really different than what's happening in civil lawsuits, which is where the power of the law is already stacked in favor of a corporation. The corporation is much more like the government seeking a way to take away someone's liberty than an individual who is potentially going to be shackled and removed from society for a very long period of time. And I think that has a lot to do with the fact that corporate lawyers have been spending decades, probably centuries, I don't even know, building law that is favorable to corporations. So I do think that as individuals, as we go through our legal careers, and especially once we get to a place where we have the opportunity to decide who we want to represent, we do have a responsibility to say, no, I'm not going to help you.
Okay, I'm gonna wrap things up here, and I think we have a few minutes if anybody has any questions, but I just want to take a moment to thank all of my panelists. This is incredible. I love learning from all of you. And I do want to just end on the note that if you have the privilege to be in this room, that means you have some amount of privilege, and I hope and I know that everyone in this room reflects on that and uses it for goals that we can all be proud of. Thank you.
I would also like Lisa to share what her article's about.
I already said Fed talk, boo. But also the fact that the Federalist Society is funded by corporate oligarchs, and they've created this idea of like free speech and debate, but it was bought by a weapons manufacturer decades ago to protect weapons manufacturers. That's all.
What?
To kill people.
You gotta read this.
Thanks. So I guess this is more of a personal question, but I think something I've been struggling with is like your responsibility as someone in the room to speak up and say something when you hear things that are kind of going off the rails, versus kind of like the personal cost that exacts on you, whether like internally or externally, and how you are viewed by your peers, etc. And so how have y'all found ways to balance both of those things?
I'm going to take this because I did brand myself angry lesbian in law school, but that was not something that I chose for myself. Like, I was called that, and I've been called worse, and it's not fun, and it's not an easy choice, and I'm able to make it because I have a lot of privilege, and I think especially as a white person in an institution like this, where there are so many conversations that go off the rails. This is an everyday choice, and it's not one that you have to make every single day. You are not alone responsible for carrying the burden of changing the minds of everyone at this place. I think for me, I do it when I feel like I have the power both emotionally and, with my own privilege. But that's not always the case. There are times when I walk away, probably not as often as many people would like, but there are times. And I think the fact that you're even asking that question shows that you're carrying a lot of thoughtfulness that a lot of others aren't, and be proud of that and keep carrying that, and know that also something that's been really important for me here is I've gone a lot of my life being told that speaking up is going to make me unlikable, but there are people here that love me because I do, and there are people that will love you for that too.
I'm very loud. Can I just yell? Yeah. Okay, so there are some people in the audience that
career options, what is the breakdown in communication or finding different options?
I can take that. I think it would be so helpful if to hear about those options at the start of our first year. So like beginning of 1L around, I want to say November, December, this might have changed, but students start receiving emails about thinking about what they want to do in the public interest space. And then for diversity students for big law firms, start thinking about if they want to do that for their 1L summer. And I think that that's the moment where students start to start to feel as if they only have two options, which is one, to make a lot of money and do the type of work that they aren't interested in doing, or two, not make as much money as they would like to make and do the type of work that they're passionate about and don't recognize that there's a middle ground that exists. And so I think telling students about that in that moment will create this desire to get that additional information and to start thinking about that more. So that would be very helpful, one. And then two, I also think providing some sort of an understanding of what folks can do after working at that firm or what their long-term career will look like, because there's just less information out there, and so it's harder to determine how that will impact your career. So the more information, the better, and I think that the more that is normalized and created, and the more students will actually start moving into those spaces as well.
You also can fund our affinity groups, give us free lunches.
Just want to add too, if you're a teacher, talk about plaintiff's terms when you talk about cases. Talk about who's bringing the cases. I don't know how many I know there's one teacher in the back over there, but he does a pretty good job.
Avid Labs against a guardian of a kid who had drunk their contaminated formula and had brain damage, severe brain damage. And I asked, is this lawyer, who was named in the case, is this lawyer, do you think when she was in law school, sitting where you were 30 years ago, that she said, this is what I want to do in my life. I want to represent a company to absolutely make sure that some brain damaged kid as a result of our products does not see a penny from us. And if you see that as not where you want to be going, then the exam is an exam to ask yourself every few years. You need to schedule it. 2 questions, we work it out in the class, 2 questions. 1, am I proud of the work I'm doing? And 2, am I the person I want to be? So I think even the people here who I take it are more committed than average to, maybe much more committed to public interest work. As your career goes on, I think it's really important that you continually ask yourself those questions.
One more right here.
I imagine many of you in this room are going to be influential in government, in nonprofit organizations, in legal services, and I want to encourage you to push really hard for higher salaries. It's never going to equal big law, but there is no reason that the Equal Justice Works Fellowship and the Skadden Fellowship pay under $60,000 a year. Last I checked, the executive director of Equal Justice Works made $500,000. Skadden is a giant law firm. They can pay Skadden Fellows better. Legal services, if they had more funding, could pay attorneys better. And that would really, truly open up the pipeline for a lot more people. As some of you have already acknowledged, I went into legal services because I could afford to do it. Most people can't, but there's no reason that we have to accept that as a given. The legal services salaries have just remained stuck at the bottom. It just doesn't have to be that way. I also think unionized nonprofits are great, unionized legal services are great, they push for higher salaries. So, just to encourage all of you to say, you don't have to accept that doing good work means a lifetime of relative poverty. You may never make big law money, but there's absolutely no reason we can't be paying people who are doing this essential public interest work better. That's just a choice that we're making, and we should stop making that choice, and we should stop accepting that choice. And I would encourage all of you to really sort of deeply look at those salaries, who's setting them, and why they're set as low as they are. And thank you so much for this conference and this panel. It's been really great.
One more.
Okay, last question for real this time.
Hello. Oh, yes. Hi. Firstly, thank you all so much for putting this on. This has been great. I'm a 2L BU, and Sam, I really appreciate your shout out for Professor McLean. And it got me thinking a little bit about kind of how law schools tend to put in the way of our graduation Federalist Society professors. For example, at BU, there's Professor Gary Larson, who literally founded the Federalist Society. He teaches 50% of every 1L class in property and is the most popular admin law professor. So I'm thinking a lot about how we could reasonably resist that. Because obviously their ideas permeate throughout these classes. They're trying to influence students and push students into corporate culture a lot more. And I feel like when you're just shepherded in assigned a 1L professor who just has an abhorrent ideology, it's really hard to resist. So I wonder if you've done any thinking about that as a panel, or if you have any thoughts.
Direct action. That's my answer. There are more of us than there are of them. I think we should unionize students too.
Yeah, and I think if you are stuck with that professor, refuse to take what they're saying seriously. I know there's been a professor that I had, I don't think he's FedSoc affiliated, but I don't know, maybe he is, who, people kept asking, what about, I know Lisa had this professor, I don't know exactly what the language was, but it was something like people were saying, what about this poor woman who was, you probably know the case better than me, and you just kind of why are we so concerned about that? And don't just settle for that answer. Let the professor know that you actually don't take that seriously, and I think if there are students who are really pushing back against that sort of teaching, the law school's gonna have to notice at some point, because for them, having students be outraged is their worst nightmare if they have to deal with that.
Take it to the media too.
Great, thank you all so much.